So I want to talk about one of the most critical phases of any divorce, and that is temporary orders. Most people don't know what temporary orders are, but it's generally something that happens early on in the case. And it's essentially orders that are either made by agreement between the spouses, that are issued by the court governing the spouse's behavior and conduct during the divorce. Temporary orders establish who's going to have the exclusive right to occupy the marital residence, or who's going to have to move out. Temporary orders govern what the visitation schedule for the children is going to be like while the divorce is pending. It's important to recognize that a divorce is like any other lawsuit. And lawsuits, as we know, can drag on for months, if not years. And during that period, there needs to be orders in place establishing, again, what is the schedule going to be for the children? What temporary child or spousal support is going to be paid? How are the household bills going to be allocated? Who's going to have the exclusive right to run and operate and manage a business that is owned by one of the spouses during the marriage? If the spouses can't agree on those issues, then you have to go to court and put on evidence just as if you were in trial, and a judge is going to establish those orders for you. And they are particularly critical in the child custody context because temporary orders establish a precedent that is unlikely to be changed when you get to final trial, whether that be 6 months or over a year later. Meaning, if you win at temporary orders on child custody, if you get designated as the primary parent and the other parent has less possession time, that is very likely going to be the order that ultimately becomes the final order in your case. So it's a very high stakes step in the divorce process. So let me talk a little bit about how we get to the temporary order stage. The first stage when you file for divorce is filing the divorce petition. You file a petition for divorce, and the petition essentially outlines what you want the court to do, what you're asking the court to ultimately give you. If you're asking for temporary orders, then those are going to be spelled out in your petition for divorce. Your other spouse gets served with that petition, usually within 3 or 4 days, depending on when the county clerk issues citation. And once your spouse is served, then they will have approximately 20 days to file an answer and a counter petition for divorce, spelling out the relief that your spouse wants. Once both sides have entered an appearance in the lawsuit, then you can have a temporary orders hearing in the event that you don't agree. So generally, courts don't force people that are going through a divorce to live together. You file for divorce, you may want the other spouse to move out. If your lawyer and your spouse's lawyer can't agree on these issues, then we have to set a hearing. That hearing can take place in a matter of weeks after your spouse has been served with the divorce petition, which means you have to start gathering and collecting evidence for your lawyer to potentially use at that hearing early on in the process. And then if we can't agree on the temporary orders, then we go in front of the judge and we have a hearing, and you'll have to testify, and you can bring other witnesses to testify. And it's essentially a mini trial that is happening at the beginning of the lawsuit as opposed to the end. And that's one of the unique aspects of family law and divorce litigation, is that we have these temporary orders, these mini trials that occur early on in the case. It's also important because it gives you a flavor for how your lawyer is going to perform in court when the stakes are highest. If you have a lawyer that doesn't deliver at temporary orders, that can be a good time to look into potentially changing counsel.